Welcome to Transnational Competition Law course, and dear learner, and today we are going to discuss the extraterritorial application of the competition law in India, and precisely what we are trying to reflect upon in the last lecture on the issue is the fact that how the extraterritorial application of the competition law in India is going to be enforced, or it can be promoted at the transnational competition law and the transnational level. That remains a moot question, because having a provision as section 32 of the competition act is said to be enough to promote extraterritorial application of the competition law. Then we have section 36, then we have section 39, and a combined reading of the application of the section 32, which have taken care of section 3 of the Competition Act, section 4 of the Competition Act, and which has also taken care of section 5 of the Competition Act, and it has also taken care of. Welcome to Transnational Competition Law course, and dear learner and viewer, we have been examining the nature and extent of the extraterritorial application of the competition law. Dear learner and viewer, you can rightly recall my previous lecture on the point wherein we have deliberated in details about the functional purview of the section 32 of the Competition Act 2002, and we have noted the fact that how section 32 of the Competition Act happens to safeguard the extraterritorial and transnational competition law. At one side, it tries to take care of section 3, section 4, section 5, and section 6 of the substantive competition law. On the other side, it also tried to safeguard the procedural competition law in the shape of section 19, 20, 26, 29, 30 of the Competition Act. And then we tried to see that what exactly has been meant by the nature and content of the power of the Competition Commission of India. We have seen that the Competition Commission of India is not only having a power to have an inquiry and investigation, but also seem legitimized to pass any order against any competitive practice which it deems necessary and fit. In that reference, we have to refer to section 36 of the Competition Act, which tries to see that how the Competition Commission of India is going to thrash out its enactment and the enforcement of the order, meaning thereby how the Competition Commission of India is going to regulate its own rules of business, conduct of business, and laying down the procedure. In this regard, we have seen the canons of the natural justice and the Indian law on the Civil Procedure Code, and as well as the Competition Commission of India General Regulation 2009 as a matter of the delegated legislation passed in the backdrop of the Competition Act. Then we have seen and examined the very enforcement of the extraterritorial application and transnational application of the competition law in reference to section 32, and then we have tried to reflect on the fact that how an appreciable adverse effect into the Indian relevant market attracts condemnation of section 27 and as well as 31, because both the section talks about that how the orders of the commissions are to be applied in right earnest, and for that matter section 27 and 37 assumes importance. Equal significance happens to be the section 39, which talks about the recovery of the penalty, and the recovery of the penalty should be on the lines of the recovery of the areas of land revenue as provided under the Civil Procedure Code, and as well as the recovery of the income tax as provided in the Income Tax of 1961. And we have referred to a case of the Meta Platform Incorporation and Competition Commission of India to conclude the point and bring home the conclusion that the Supreme Court itself has taken note of the fact that the Competition Commission of India is an independent authority to consider any violation of the provisions of the Competition Act when there is certain circumstances which prima facie reflect, and therefore the Supreme Court of India has rightly upheld the suo motu jurisdictions of the Competition Commission of India in reference to updated terms of service and privacy policy for WhatsApp users in India. With this, what remains important from our point of view to look at that the power of the commission to have inquiry, to have investigation, and to pass any kind of an order and have a suo motu cognizance of any issue as has been put a seal of approval by the Supreme Court of India, that this Competition Commission of India as an independent authority can consider any violation of the provision of Competition Act when there is a prima facie case for the violation, and the proceeding which are initiated by the Competition Commission of India cannot be said that they are lacking some kind of the jurisdictional vacuum or jurisdictional capacity. With this, the Supreme Court of India also tried to buttress the point and quoted a famous case of Competition Commission of India versus Steel Authority of India of 2000 decision, wherein the Supreme Court itself has reiterated the point that the Competition Commission of India should not be restrained from proceeding further with the inquiry and investigation of any alleged violation of any provisions of the Act of the Competition Act. Taken together, dear learner and viewer, the point which I am going to make in the present lecture is very simple. The point is that the Competition Commission of India's omnibus power to look at the violation of the Competition Act 2002, be that the suo motu power, be that appeal, be that the complaint, be that what it considers necessary and expedient, and the Supreme Court's ruling in case of the updated terms of service and privacy policy of the WhatsApp user in 2022, and its earlier case of the Competition Commission of India versus Steel Authority of India, showing that the jurisdiction of the Competition Commission of India is wide enough to cover all kinds of cases of the violation of the Competition Act. Here, what I just wanted to conclude is the point that in matters of the transnational application of the competition law, or in matters of the extraterritorial application of the competition law, the power of the Competition Commission of India, as we have seen, that be that the procedure, be that the rule of governance, be that the regulation, be that the enforcement, be that the recovery of the fines and making the compliance of the order, what important issue remains out of the ambit and scope of Section 32 is the fact what is known and what is to be considered, that what is going to be held in furtherance to the objective of Section 32 of the Competition Act. And from that point of view, meaning thereby that what advancement is going to create and what stride it is going to have and what quantum jump it is going to have on the strength of such a salubrious provision known as Section 32, which confers extraterritorial or transnational application jurisdiction to the Competition Commission of India, that needs to be appraised, that needs to be understood as to what the Commission has done in that regard to have a further development, because having understood Section 32 or having understood there is enormous power of the Competition Commission of India will not serve the basic purpose of having a competitive global market and a competitive competition law, or having a transnational competition law. In that respect, we require that we have to look at the Section 18 of the Competition Act with a very careful eyes, because Section 18 of the Competition Act talks about the duties of the Competition Commission of India, and I am going to read that how what is the canvas and what is the purview of the duties of the Competition Commission of India. And the section goes on to envisage, subject to the provision of this act, it shall be the duty of the Commission to eliminate practices having adverse effect on competition, promote and sustain competition, protect the interest of the consumer, ensure freedom of trade carried by the other participant in markets in India, provided, that is something very important, because here the entire depiction and portrayal of the basic objective which are underpinned under section 3, section 4, section 5 and section 6 of the Competition Act is very important. Nonetheless, what objectives of the competition law has been envisaged under section 18, meaning thereby that eliminate practices having adverse effect on competition, promote and sustain competition, protect the interest of the competition, and ensure freedom of trade. It is very important. And what I just wanted to highlight out of the reading of the section 18 of the Competition Act is the fact that provided that the Commission may, for the purpose of discharging its duties and performing its functions under this Act, enter into any memorandum or arrangement with the prior approval of the central government with any agency or any foreign country. My dear learner and viewer, the perusal of section 18 is an eye-opener to the fact that what has been contained in section 32 and what advancement it can be made, what furtherance is required on that issue, what follow-up is required on that issue, that has been answered within the functional ambit of the duties of the Commission, which inter alia include that it may consider entering into the memorandum or arrangement with the prior approval of the central government with any agency or any foreign country. Thus, in that respect, Section 18's mandate in advancing Memorandum of International Cooperation Division ICD and then the International Cooperation Division was established by the Competition Commission of India, and it is very important to see that how International Cooperation Division of the Competition Commission of India have been intensely and meticulously discharging its duties in promotion of extraterritorial application of competition law, and so far so good that memorandum of understanding was signed between the CCI and the Competition Commission of Mauritius in 2022. It was, and we find a signing of the uh, memorandum of understanding and cooperation with the chairman of JFTC and with the country of the Japan Fair Trade Commission. There has been a memorandum with the Council for Economic Defense of the Brazil in 2021. We have a memorandum with China. We have a memorandum with South Africa. We have a memorandum with Russia, meaning thereby that if we peruse the growth and development and the activities of International Cooperation Division, we find that all BRICS countries, that the Government of India and the Competition Commission of India happens to sign memorandum of understanding among the BRICS countries, among the European Commission, among the countries like Australia, countries like USA, and countries like Russia. And we also find that the Japan, the Mauritius, and some other countries have also entered into an agreement. That is something very important to keep into the process, because what has been laid down under Section 18 of the Competition Act, a replica of that act is visible under Section 44A of the Civil Procedure Code, because we have seen in the entire procedure of the Competition Commission of India that it incorporates the canons of justice, natural justice, and it also incorporates partly the Civil Procedure Code, and its reliance on the Civil Procedure Code assumes importance here, that besides what is being done at the International Cooperation Division on the strength of Section 18 of the Competition Act, we should also read it together with the mandate of Section 44A of the Code of Civil Procedure Code, which have listed United Kingdom, Aden, Fiji, Republic of Singapore, Federation of Malaysia, Trinidad and Tobago, New Zealand, and uh, country like Hong Kong, Papua New Guinea, Bangladesh, and United Arab Emirates. A perusal of Section 44A of the Code of Civil Procedure, which tries to create a kind of a structure that the section gives the provision for the enforcement of decree or orders in reciprocating territories, and for the reciprocating territories and the enforcement, that is very important. If the Competition Commission of India is going to decide on any kind of the competition concern, be that the anti-competitive behavior or regulation of the combination or abuse of dominance or the merger and amalgamations, so any kind of order must be enforced in a transnational manner, and the enforcement in the transnational manner well depends upon Section 44A of the Civil Procedure Code, that talks about the enforcement of decree or order in reciprocating territories. And what we have learned, that India so far has a reciprocating agreement and with many countries, which include 11 countries. So there is a need to look at afresh that what can be done from the point of view of the Competition Commission of India's power and function in giving more countries, bringing to the fold of Section 44A of the Civil Procedure Code, because that is something very important. And that also leads to the another issue of Section 14 of the Civil Procedure Code, which simply envisages that the presumption as to foreign judgment as judgment pronounced by the court of competent jurisdiction, unless the contrary appears on record, is also very important. Therefore, when we are going to enforce the judgment of the Competition Commission of India in transnational matter, we should have a series of memorandum of understanding, as well as to, to reinvigorate Section 44A, or we should comply Section 39 of the Rule 5, Section 39 of the Civil Procedure Code, especially the Rule 5 and 6 of Order 21 of the Code of Civil Procedure, besides the application of Section 14 in matters of enforcement, transnational enforcement of the competition law. With this, we find that it's not only the order has been passed, but we have to see that how the orders of the Competition Commission of India, besides having its application and enforcement by Section 27 and 31 and the 39 of the Competition Act, we have to be equally conscious of the fact that what has been laid down under Section 18 as one of the duties of the Commission to have any kind of a memorandum or arrangement with the prior approval of the central government, it should be broadened, it should be enlarged, and to give effect to the transnational competition law. Vis-a-vis, we should also look into the mandate of Section 14 of the CPC, Section 39 of the CPC, along with the Rule 5 and 6 of Order 21 of the CPC, and ultimately the rule of the reciprocity of under Section 44A of the Civil Procedure Code, to see that any kind of an appreciable adverse effect in the Indian market, or any kind of a competition concern, or any kind of a violation of competition law through the Competition Commission of India's order, can be honored in India and as well as in foreign jurisdictions. With this, dear learner, I end to the transnational application of the competition law by raising your attention to a very important issue of indulgence and engagement of a very high degree to develop some kind of a collaboration, some kind of a reciprocity, some kind of the understanding among all the foreign countries in matters of compliance of the competition law. With this, I conclude and I thank for your patient hearing and I wish you a happy learning.